Hey, Miss Esmeralda, can you hear me? No. She's muted. You can hear me, Kevin?
Yes, sir.
Okay. I don't think anybody else can.
I can hear you, Dana.
I was just trying to verify the family's address before we get started.
Okay. Miss Samora, can you hear us? Okay. I think she said, yeah, she's just muted.
Yeah.
He's unmuted.
Thank you, Judge. I just wanted to verify the address before we get started. The one that I had from way back when was 8701 West Freeway.
Yes.
Room number 123. That's still accurate?
Yes, sir.
All right. Thank you.
All right, it is Friday, May 22nd. We're hearing cause number 323-11-2053-19 in the matter of Alyssa Criolla Mackey. Are you Miss Mackey?
Yes, sir.
What's your date of birth?
January 19, 2004.
And that makes you how old?
I'm 16.
All right. Mr. Allen, I have before me a document entitled Acknowledgement of Receipt or Disclosure of All Documents, Items, and Information Provided to the Respondent under the Texas Family Code. Are you satisfied with the discovery provided by the state in this case?
Yes, Your Honor.
All right. While the Texas Supreme Court has closed the courthouse for live hearings except for essential hearings, in keeping with the spirit of the open courts provision of the Texas Constitution, this hearing is being broadcast on YouTube, but voice only. Anybody who may be listening or watching, rebroadcasting or recording of this hearing in any shape, form, or fashion is prohibited. Violation of the court's order with this regard is punishable by civil and/or criminal contempt. Ms. Mackey, before we can continue, I've got to go over several things with you. First, I have a document titled Waiver of a Hearing Before the District Judge. Is that your signature down there?
Yes, sir.
All right. Are you telling me you want to have this hearing in front of me rather than Judge Kim?
Yes, sir.
All right. Our law also gives you the absolute right to have a jury trial in your case. And that would be where a group of citizens would be called in from the community, and they, not the judge, but the jury would determine whether or not you actually did what the state has accused you of doing. As part of a jury trial, you could force the state to call all the witnesses who might testify against you. You would get to look them in the eyes, and then I would put them under oath. Your lawyer would get to cross-examine them to make sure they're telling the truth. And at the end of everything, the jury, not the judge, but the jury would determine whether or not you actually did what the state has accused you of doing. Do you understand that?
Yes, sir.
All right. Now, I have before me a document with 2 paragraphs on it. The top paragraph says stipulation of evidence, but the bottom paragraph says waiver of a trial by jury. Is that your signature underneath there?
Yes, sir.
Are you telling me you do not want a jury trial in your case?
No, I do not.
Okay, and you want me, Judge Porter, to decide everything. Is that correct?
Yes, sir.
All right. Our law also gives you the absolute right to remain silent and not say anything at all. Nobody can force you to talk about this case in open court. The prosecutor can't force you. Your probation officer can't force you. Not even I can force you to talk in open court about this case. The only person who gets to make that decision is you. Do you understand that?
Yes, sir.
Now, because it's your decision, you can choose to give up that right to remain silent, and you can talk about that case. You understand?
Yes, sir.
Now, let's go back to that document with 2 paragraphs on it. That top paragraph, it says stipulation of evidence. Is that your signature underneath?
Yes, sir.
All right. And next, I'm going to show you a 2-page document titled Stipulation of Evidence, Judicial Confession and Disposition Agreement. At the bottom left corner down there on that first page, is that your signature?
Yes, sir.
All right. Did you have a chance to go over both of these documents with your attorney?
Yes, sir.
And if you wanted to ask any questions, did he give you a chance to ask questions?
Yes, sir.
And if you did ask any questions, did he answer those questions to your satisfaction?
Yes, sir.
Do you understand that by signing these 2 documents together, you're actually confessing to doing, you're admitting to doing what the state has accused you of doing? Is that what you want to do?
Of evading arrest?
You understand that by signing these documents, you're admitting to doing what the state has accused you of doing?
Yes, sir.
All right. Did anybody pressure you to come in and do that today?
No, sir.
Did the prosecutor trick you into doing it?
No, sir.
Did the President of the United States call you at home last night and promise you $1 million and a full presidential pardon if you'll just come in and plead true before Judge Porter today?
No, sir.
Nothing like that happened?
No, sir.
All right. Are you telling me the only reason that you're pleading true today is because that's what you want to do?
Yes, sir.
And the only reason you sign these documents is because that's what you want to do?
Yes, sir.
All right. Mr. Allen, you've had a chance to get to know your client for a while. Do you have any reason to believe that she does not understand the charges or charge against her?
No, Your Honor, no reason.
You believe she understands the ramifications of what she's doing here today?
Yes, sir.
All right, Ms. Mackey, the next 2 questions the U.S. Supreme Court makes me ask of every kid who sits in that chair. Are you an American citizen?
Yes, sir.
Where were you born?
I was born here in the United States.
Okay, and what city in the United States?
Fort Worth.
Pardon?
Fort Worth.
Fort Worth. And what state in the United States is Fort Worth in?
Texas.
All right, I know it sounds silly, but I have to ask that of everybody. All right, Ms. Mackey. In paragraph 1 of the state's petition filed on October 16th of 2019, the state has alleged that on or about October 8th of 2019 here in Tarrant County, Texas, okay, state, are we proceeding on an evading arrest or a resisting arrest?
It should be resisting, Judge. What's
Okay. Well, she said evading earlier.
okay?
Okay.
Do I have the correct paragraph on there?
Well, I'm looking at the petition. It said resisting,
Yeah,
and the stipulation says resisting.
Okay.
I just wanted to make sure.
Yes, sir.
All right. Ms. Mackey, the state has alleged in its petition filed on October 16th that on or about October 8th of last year here in Tarrant County, Texas, you intentionally prevented or obstructed Jay Bonilla, a person you knew to be a peace officer from effecting an arrest, search, or transportation of you, or another by using force against that peace officer, namely by pulling away from J. Bonilla, twisting your body, and struggling with J. Bonilla. We commonly call that offense resisting arrest, and it's a misdemeanor. Do you understand that charge?
Yes, sir.
Was that yes?
Yes, sir.
Okay, I'm sorry. Is that allegation true or not true?
It's true.
Okay. Are you telling me it's true because that's what you want to do here today?
Yes, sir.
Did anybody force you to do it?
No, sir.
You're telling me that the person who made the decision to come in and plead true today was you, not somebody else, right?
Yes, sir.
All right. Does either side believe there are any additional admonishments that need to be given in this case?
Sir.
No, Your Honor.
All right. Based on the evidence before me and based on our interactions, Mrs. Mackey, I find that you are competent to enter a plea of true. I further find that you did engage in delinquent conduct as alleged in the state's petition. Such conduct would constitute a misdemeanor if engaged in by an adult, and such conduct constitutes delinquent conduct under the family code, and that will be the order of the court. We're back on the record in cause number 323-112053-19 in the matter of Alyssa Crayola Mackey. We're here for a disposition hearing. Pursuant to Rule 201 of the Texas Rules of Evidence, the court takes judicial notice of the contents of the court's file as well as all hearings over which the court has personally previously presided. Are both sides ready to proceed?
Yes.
Yes, Your Honor.
State?
State would offer petitioner's exhibit number 1, the social history.
Mr. Allen, have you had a chance to review the social history in advance?
Yes, Your Honor.
And are you aware of any additions, corrections, or deletions that need to be made there too?
No, Your Honor.
Do you have any objection to the admission of petitioner's exhibit 1?
No, Your Honor.
Petitioner's exhibit 1 will be received and admitted. Who would the state call as its first witness?
State would rest.
All right. Mr. Allen.
The defense rests, Your Honor.
All right. Summation.
Your Honor, we would just ask that the court follow the agreed plea agreement recited in the stipulation of probation for 14 months with the family partnership program assessment. Thank you.
Mr. Allen.
Nothing further, Your Honor.
All right. If you'll give me just a minute to review the social history. right, Ms. Mackey. I find that you are a child in need of rehabilitation. I further find that granting probation is in your best interest as well as the best interest of the community. I will order you be placed on probation for a period of 14 months. During that term of probation, I will waive court costs and I will also waive any probation fees. I want you to attend and successfully complete the FPP program. You'll have 50 hours of community service, and I will tell you that is less than I would normally order. I want you to write a letter of apology to the police officer in this case. Okay? You're going to turn that into your probation officer.
Yes.
And that is due within 30 days. Okay?
Yes, sir.
You are to submit to random UAs as requested by your probation officer. And given her history, I also want a drug assessment to be done, and we will evaluate if any treatment is needed, but I'd rather wait and see how that assessment comes out and give both parties a chance to address whether or not treatment is needed. Because based on the social history, I'm not convinced it's needed, but I want everybody, including mom, to have a handle on where she's at in that process. Anything else from either side?
No, sir.
One question, Your Honor. I missed how many hours of community service?
50.
Thank you, sir.
All right. Anything else, Mr. Allen?
No, Your Honor.
All right. Thank you. That'll be the order of the court. Good luck.
Thank you.
Thank you, Judge.
Thank you, Judge.
Go ahead, Beatrice. Hello.
Good morning. How are you?
I'm good. Yourself?
You're better than I deserve. Give me just a second. All right, what's up?
Well, it just depends on which one we're doing first right now. One of them looks like I guess we're waiting on Miss Farmer.
Okay.
We should have an agreement for one, and then the other one is, we've had a change of circumstances at the very end, so I need to talk to the mom and the child again.
All right. Which one? So I'm assuming you're going to be asking for a continuance in that second one.
On Perez, we'll be asking for a continuance. We're going to do a DPP, but they don't have all the money yet, but they're going to put a down payment today.
Oh,
and
okay.
So next time they can pay the rest of it.
All right. Then I will let you get with Ms. Farmer about that, and I'll let y'all submit a written motion for that, and I'll grant it when it's submitted. So that leaves, is it Salgado?
Salgado, yeah. And we were almost going to do a DPP, but at the last second, the probation office doesn't think it can work. So I need to re-talk with the mom and the child again and let them know what's going on.
All right.
They should be up there, but I've been trying to call her during the last half hour and haven't got a hold of her. It keeps going to voicemail. So as soon as they come in, I'll talk to them.
And I can create a breakout room for y'all to talk privately.
That'd be great.
Let's see. I have not seen Ms. Aguirre today. So she may be visiting with the family.
Oh, Selena?
Correct.
Okay. Yeah, I still had my paper still showed the previous one, so that'd be good. All right, and that's where we are right now. So we should be able to take care of one. The other one may go to a plea. We did get an offer from from Miss Farmer, so we're just waiting to talk to the family.
And there's Miss Farmer. Ms. Farmer, did you and Mr. Masick want to have a chance to talk privately?
I'm sorry, Judge, could you please repeat yourself?
Did you and Mr. Masick want to have a chance to talk privately?
Yes, Your Honor.
All right, let me create that for you.
Thank you.
Thank you, Your Honor.
Oops. There you go.
Thank you,
Your
Judge.
Honor. All right, Ms. Farmer?
Oh, wait, you'll need to go into the breakout room.
Oh, you go into it. Oh, join. Okay, I see. Sorry about that.
That's okay.
All right, Larry is coming in person.
Is or is not?
Is not.
Okay.
Video in a minute if you need.
All right, what's up?
Judge, well, I'll let Ms. Farmer first talk to you about the Perez case.
Okay.
Yes, so the probation officer, Mr. George Nava, came by my office and said that Julian Perez is going to be able to pay all of the restitution today. So
Okay.
I will be DPPing that case as soon as I get word that that's been paid. As far as the case with Jose Luis Salgado, I believe we just need Mr. Masick just needs to talk to the family. An offer's been made on that case. Mr. Masick just needs to convey it and see kind of where they're at.
All right.
That's my understanding, Your Honor.
Ms. Farmer, would you be willing to submit a written motion for continuance on behalf of the respondent, citing those reasons for continued plea negotiations?
For Mr. Salgado?
Yes, for both sides.
Yes, Judge, if we need to do a continuance, I do believe the family's on their way, though, if you have time to wait. I don't know if you do.
Oh, y'all, okay. No. We can do it today because I've got 15 minutes until detention hearings.
Oh, okay. So, well, if need be, I would work a continuance up. But from my understanding is that the mom was bringing him up there today.
Okay, well, then when he gets here, I will get them into the family room, give you a chance to talk to the respondent and the family, and then y'all can let me know what happened.
Thank you, Your
Thank
Honor.
you, Judge.
No problem. No problem.
All right. Do we just stay on this channel then until?
Yeah, if you want to, do you have their phone number if you want to call them, please?
I will call them again right now.
Yeah, I'll be on here. Just let me know if you don't want to talk to me on this, you can call me on the phone as well.
Okay. Well, I'm just going to mute you right now while I'm giving you a call then. Or while I'm giving them a call. All right. Thanks. Hello, Ms. Farmer. I was able to talk to the mom, and she says that she talked to Miss Aguirre and offered to supervise when the boy went up there. I don't know if that'll work, but Miss Aguirre said she was going to check on that. So can we check on that with Miss Aguirre?
Do you mind giving me a call to my office phone number?
Yeah, I'll call you that.
I'm not sure who you're talking about with Miss Aguirre. Oh, with Selena. With Selena.
Selena. Yeah.
She's willing to supervise how many hours?
Yeah, whatever hours it needs to be done. But
okay.
You know, I haven't talked to Miss Aguirre, so I don't know right now.
Okay. We may have to file a continuance then, because I know, Judge Porter, you're kind of approaching your detention docket.
Correct. Although my afternoon is completely free.
Okay.
And I only have 5 detention hearings. They'll start at 10:30. I would say worst case scenario, we're done at 11:30. So if y'all needed time to talk and come back at 11:30, anytime between 11:30 and 5, I'm here. Or if y'all want to reset it for a different day.
Okay. I think we both need to talk to the probation officer. So maybe if we come back at 11:30.
Okay.
And if not, we'll file a continuance.
That sounds good.
All right.
Okay. Thank you, Judge.
All right. Thanks, y'all.
Thank you, Judge.
Mr. Masek.
Yes, Your Honor.
Before you leave, go ahead and keep your computer open to this. That way, if the family shows up and you want to talk privately with them over the Zoom link, you can do that.
Okay. They are there at the in the lobby.
Okay. Well, then if you want to talk to them over the Zoom link, you can do that. Or if you prefer to just talk to them over the phone, I'll leave that open to you, whatever you want to do.
All right, I appreciate that. I'm just going to put you on mute then at this time, and then also talk with Ms. Farmer regarding the probation officer.
All right. Then what I will do is, there's nobody else in here but the two of y'all. I'm going to put my computer on mute, and then I will turn the sound off on mine so that I'm not hearing what y'all are saying.
Okay, thank you, Judge.
Thank you, Judge.
All right, I am now muted.
You're muted.
Okay, Mr. Mastic. So you were saying that Miss Aguirre is willing to supervise the 160 hours?
No, not Miss Aguirre. The mom, Maria Lara, told me that her and Miss Aguirre were talking, and that the mom offered to supervise whatever hours she need to go out there. But I don't know if that's going to fly with Miss Aguirre.
Oh, okay. I see what you're saying. Yeah, and I think, okay, and I was a little bit confused what you were talking about. And I obviously didn't want to. I'm glad Judge Porter said that he would step out. So I don't know if it was appropriate to negotiate in front of him, but
Probably not.
yeah, so I didn't want to put him in that position either. Sorry. 1 second.
Go ahead.
Sorry, someone stepped into my office. Yeah, I don't know if that's gonna work out. What did Miss Aguirre say about that?
You know, I don't know. I haven't talked to her yet, so I'm gonna.
Okay.
I need to call her on the phone if she's at her office.
Yeah.
You know what her line is?
Yeah, if you want, I can call her and conference call you in. That way the three of us can be on the phone together.
That'd be great.
I understand the mom's willing to supervise, but I just don't know if that's going to work out.
Yeah, I know. But that's because she said she doesn't have the $6,000. So.
Yeah, and I'm guessing they don't want to do the 12 months probation.
Well, she actually, what she really wants is him to be doing the work.
Mm-hmm.
She wants him to be doing something constructive.
Okay, well, let me let me try calling the her again, and I'll try calling the principal again too as well. See, because probation said that they would need someone, I think, from the school to be, I guess, willing to like have him do like a sign-in sheet or something like that. And I don't know if they have anyone like that.
Yeah, especially over the summer. too.
Yeah, so I just don't know if it's going to be possible. But I'll try calling the school again, and then try calling Selena. And if I can get a hold of Miss Aguirre, I'll try conferencing you in.
I don't know if it'll be feasible to keep the family there this many hours. So we might, if we don't reach it right now, maybe we can reach it. Well, let's go ahead and find out what we have available right now.
Okay, yeah, I agree with you. It's kind of looking like we're gonna have to do a continuance, but I can make some calls and we'll see where we're at.
Okay.
Okay.
I'll stay on here then.
Okay.
Or do you want me to?
You can stay on here. I'm just gonna close out my camera and mute it for now.
Okay, that's fine. Okay, I'm back.
Okay. Do you want to maybe call Judge Porter and see if he can do a breakout room with you and the family?
Yes, I'm going to, and I guess he could send the bailiff to get them.
Yes. Okay, so if you want to give them that probation offer, we can kind of see, maybe if they do want to do that, maybe we can squeeze it in before his detention docket, if not another day.
Yeah, I'll talk with him. So what do we need? How do we contact Judge Porter then?
Let me see. Let me call. Let me call Mary really quick. Oh, she's on here. Hey Mary, are you in your office? Oh yeah, because you just answered the phone. I'm on the Zoom hearing with her. Okay, I believe Judge Porter is about to get back on, so we can ask him to create you a breakout room.
Okay. All right. And then I'll just wait for him to get on right now. Not a problem.
All right, y'all. Ms. Farmer, Mr. Masick.
Hi, Judge.
Yes, Your Honor.
Oh, wait. Sorry. I still had my volume off on my computer. Okay.
Yes, Your Honor. What I'll need is to get is to make a breakout room so I can talk with the family, because I don't think we can get the deferred part in place. What we were trying to negotiate, and so if we can talk, I can get a chance to talk with the family in the breakout room.
All right. Let me go see if we can get the family back to the parent room real quick. Okay.
If we can't get this all done right now, we are ready to file a motion for continuance if you need, considering if you're going to be in detention hearings.
Yeah, we won't be able to do this plea and everything within 25 minutes. So what is the family's last name?
Salgado is the boy's name, and the mom's name is Lara. Lara. L-A-R-A.
L-A-R-A and Salgado. So if you will take Ms. Lara and Mr. Salgado back. Hold on. Where's my the kid's first name?
Jose. Salgado.
Yes.
Okay, I'll just look.
Yes. And take them to the parents' room, and I'll create a chat room for Mr. Masick and the family.
Thank you, Your Honor.
Thank you, Judge.
And then meanwhile, I will trust that Ms. Farmer can submit me a written motion on your behalf, Mr. Masick.
Oh, that'd be great, Your Honor. I was going to contact my legal assistant to start one, but if she's already there, probably be easier. Right there in front of the computer. I'll get with you.
All right, Ms. Laura, this is Judge Porter, and I'm going to create a private chat room for y'all to talk to Mr. Masick. So when it comes on the screen, please select or please choose join. All right, Mr. Masick, you should be able to go in there now.
Okay. Thank you, Judge.
You're in there.
Hold on. Vincent speaking.
Hi, your family's here.
Okay, thank you.
Judge, I'm still on here right now. Do you want us just to get off and then just talk between ourselves?
That's fine. You don't have a detention hearing today, do you?
I don't, Your Honor.
All right. Well, then have a great weekend.
You too, Your Honor.
Howdy.
You and Alex don't need to come by today. No, when the cows were in, I went down there last night, and they made themselves a new place.
You go around like a
Yeah, so they're okay.
Morning.
Hey, you're free this afternoon unless you want to come.
Are you Mr. Eric?
Yes.
All right. Would you tell them in detention that we are going in reverse alphabetical order today, so you'll get to be last? I'm sorry.
Okay.
Thank you.
Thank you.
Come on,
Are you Ms. Walden?
Yes, sir.
All right. We're just waiting for your attorney to get on the line.
Yes, my mom out here.
I have not seen her yet, but then I'm trying to juggle about 4 things, so. Miss Smiley?
Yes, sir.
Have you had a chance to talk to Miss Walden's mother?
I did, Your Honor. I spoke to her yesterday and this morning, and I sent her the link. I just texted her to see if she's.
I do not see her on the line. We still got a few moments. We'll wait for your attorney, though, to come on. There's your attorney. Good morning, Mr. Adeniji.
Good morning, sir.
All right. Ms. Walden, this is a detention hearing to determine if you should remain in custody or be released to a parent or guardian. My name is Judge Porter. You have the right to remain silent and not say anything at all. If there's something you want to say, please do not blurt it out. Instead, wave your hand like this. That'll get my attention. That'll get your attorney's attention. I'll create a private internet chat room for y'all to talk about what you want to say. And that you two will be the only ones in there. That way he can tell you whether or not you really should say it. Does that make sense?
Yes, sir.
Yes.
Can we do that real quick, Judge?
Pardon?
Can we do that real quick?
Yes. Be quick, though.
Yeah, that's why I said quick.
Well, I still have to remind you.
Okay.
Hold on. Okay. Okay. It's gonna take about a minute for that to close out.
Okay.
While we're doing that, I'll remind everyone that we are broadcasting these hearings live on YouTube in keeping in the spirit of the Texas Open Courts provision in the Constitution. Rebroadcasting or recording of these hearings in any shape, form, or fashion is a violation of the court's order and will subject the recorder or rebroadcaster to contempt proceedings. So give it about 20 more seconds. I should be able to create that breakout room for you two.
Thank you, Judge.
Okay. All right. I'm going to hold you to your promise, Mr. Adeniji.
Yes, Judge, I know you do that.
We do have other kids waiting. Y'all should be able to get in there now. Miss Walden, oh, there she goes.
And Your Honor, Mom is joined.
Okay, great. Thank you so much, Miss Smiley.
It's Miss Denise.
Okay. There she is.
Yes.
All right. Miss Owens, your daughter is talking privately with her attorney, and when she comes back, we'll continue the detention hearing.
Okay.
I'm back, Judge.
All right.
Did I get credit for that?
Yes, you do get credit for that. We are
Okay,
okay. Okay. And the respondent's mom is on the line. Okay, Miss Smiley, what brings Miss Walden to court today?
Ms. Walden was referred into custody on April the 9th at 3:39 in the morning by Fort Worth Police Department due to her taking her father's SUV without permission. She was taken into custody at the house where they located the vehicle. In addition to that, Your Honor, she was also received a referral while in detention due to an altercation that happened, one of several altercations that happened on April 27th. Those two reports were referred into custody, assault, bodily injury on May the 7th. They have been filed by the DA's office. One was dismissed and one was filed. A petition was filed for one assault, bodily injury. She is set for court this Tuesday, the 26th at 8:30 before Judge Terry.
All right. Wait, let me see that real quick. Miss Owens, what are your thoughts?
Judge, I ask that you retain Micaiah until her court date, just because it's so close to her court date, and she has a history of running away. Although I love my daughter and would love to see her, I just don't want to take that chance that she'll run away before her court.
All right. Miss Walden.
Yes, sir.
I know you're on. There you are. Okay. Screens are moving around for me. What did we talk about last time? What did I need your level to be at?
A level 1.
Level 1 what?
Oh, wait.
Outstanding, right? Hold on, Ms. Walden. I needed your level to be at level 1 outstanding, right?
Yes, sir.
What's it at?
It's okay. So I was
no. I don't need an explanation. It's at 1A, isn't it?
Yeah, but I'm supposed to be a 1-0 today because they missed.
Well, that you're not though, right?
No.
So our deal was you had to be level 1-0 for me to consider your release, right?
Yeah.
Did you make it?
Not today.
Okay. So what do I have to do?
Detain me.
Yes, ma'am. I know you were there yesterday, weren't you? I looked. All right. You'll get to see Judge Terry next Tuesday, okay?
Okay.
All right. Thank you.
Thank you, Judge.
Thank you, Mr. Adenishi.
Am I free to leave? I'd love to
yes,
stay.
sir. No, you're done. Have a great weekend.
Okay. All right.
All right, Judge.
I'm Ms. Owens.
Ms. Herrick, I believe you're up next.
Okay.
And Mr. Dotson, you're up too.
Yes, sir. Good morning.
Good morning. You Mr. Sanchez?
Yes.
You Mr. Sanchez?
Yes.
All right, pull your chair closer to the computer. My name's Judge Porter. This is a detention hearing to determine if you should be released from custody or you should remain in the back. You have the right to remain silent, not say anything at all. If there's something you want to say, please do not blurt it out. Instead, wave your hand like this. I'll create a private internet chat room for you and your attorney, Ms. Herrick, to talk. That way she can advise you on whether or not you really should say it. Anything you say during this hearing cannot be used against you at your adjudication or disposition hearing, but it can be used against you at another detention hearing. So, Mr. Dotson, what brings Mr. Sanchez to court today?
Your Honor, Mr. Sanchez was referred in custody yesterday on a directive to apprehend issued by Judge Kim. He was initially placed, he was in custody on May 1st for a runaway referral, and he had a pending case of UUMV where he took his mother's car and damaged it. He was released by Judge Kim on May 4th with the conditions of to stay away from his cousins, to abide by mom's rules, and be a good student at home. Mom called, indicated that he had contacted his cousins. He actually stole his sister's phone and sold it to his cousins through his older sister. He established a social media account when she told him to not do social media. And he also tested positive for marijuana. She was suspicious that he was continuing to use drugs.
Oh.
Yeah. He has court date June 1st at 9:30 with Your Honor. That's it.
So, sounds like he allegedly violated 3 of Judge Kim's rules. Don't use drugs, stay off social media, and don't commit new offenses. Mr. Sanchez?
Okay, whatever. Y'all do y'all.
Mr. Sanchez, look at me. Man, if there's something you want to say, please don't blurt it out. Instead, wave your hand like this. I'll create a private internet chat room for you and your attorney to talk, okay?
Yeah.
That way she can tell you whether or not you really should say it. Does that make sense? Is that a yes?
Yes.
Pull your chair closer to the computer.
Yes.
You need to speak up. Okay. So, Mr. Dotson, he came in and tested positive for drugs, right?
Yes, sir.
And according to the information provided to you, he stole his sister's phone.
Correct.
And according to the information provided to you from the mom, he also violated the 3rd of Judge Kim's rules in that he was not supposed to be on social media, right?
That's correct.
Ms. Herrick, what should I do with somebody who violates 3 of Judge Kim's orders?
Well, I haven't had a chance to speak with John yet today, so I'm not sure what his reasoning behind doing those things were, but
allegedly.
Allegedly, correct.
Mom is present, Your Honor.
All right. There's Mom. Okay. Are you Ms. Sanchez?
Yes, sir.
What do we need to do? What's going on? Why can't he follow Judge Kim's rules?
Because he wants to see what he can get away with the way that he was prior to coming in the first time.
Oh.
He believes because of his age that he can do what he wants and there's no repercussion for his actions.
Okay. Well, what are your thoughts? Do you think he needs to stay in detention or come home?
Yes, we gave him the opportunity to come home, and he violated everything that we put in place for him.
Okay. So what do you think needs to happen, Mom?
Would like for him to stay here.
All right. Ms. Herrick, what are your thoughts now?
I mean, obviously, I think John would like to go home. He's got, I think, 10 days before his next hearing, which is, you know, it's a lot of time. I don't know. That's all I got.
All right, Mr. Sanchez.
Yes.
Decisions have consequences. Actions have consequences. So the information provided to me is that you violated not 1, not 2, but at least 3 of Judge Kim's orders. So what do you think I'm going to do?
Stay.
You got it. That's going to be the order of the court.
Bet.
John, if you want to talk to me, tell the guards to call. Thank you, Judge.
Thank you,
Thank you, Ms. Eric. I think that's your last hearing.
Okay. Thank you.
Have a great weekend.
You too. Thank you.
Thank you, Your Honor.
Thank you, Mr. Dotson. Ms. McGonigal, I believe you're up next.
Your Honor, his ad litem is participating along with his OCLK worker, and the grandmother is also participating for him.
Okay, if you can help me identify those people. I saw them earlier, but...
Be Elka Daniel. Vicky Garza, and Valencia Wright.
All right, Ms. Garza, if you want to take yourself off mute.
Yes, sir.
And Ms. White, if you want to take your phone off mute. Okay. Are you Mr. Osborne?
Yes, ma'am.
All right, Mr. Osborne, I need you to pull your chair closer to the computer. And I need you to talk nice and loud where everybody can hear you, okay?
Yes, sir.
All right, my name is Judge Porter. This is a detention hearing to determine if you should remain in custody or be released to OCOK or OKOC, whatever we're calling it these days. You have the right to remain silent and not say anything at all. If there's something you want to say, Mr. Osborne, look at me.
Yes, sir.
If there's something you want to say, please do not blurt it out, okay? Instead, wave your hand like this. That'll get my attention. That'll get your attorney's attention. I'll create an internet chat room for y'all to talk about what you want to say. That way, Ms. McGonigal can advise you on whether or not you really should say it. Does that make sense?
Okay.
Anything you say during this hearing cannot be used against you at an adjudication or disposition hearing, but it could be used against you at a future detention hearing. Do you understand that?
Okay.
All right. Do you see your attorney on the screen?
Yes, sir.
All right.
Hold on. I can't see you.
And I know Miss Washington's here.
Good morning.
There you are. Okay, Miss Washington.
Yes, sir.
What brings
Good
Mr.
morning.
Osborne to court today?
Thank you, Your Honor. On May the 8th, Osborne was referred in custody by the Fort Worth Police Department for evading arrest. According to the report, the police officer observed Osborne operating a vehicle that was stolen, operating a vehicle on 4200 of the block of Miller Street. The officer ran the vehicle and learned that it was stolen out of Dallas. Observed Osborne in the driver's seat, initiated a traffic stop. The vehicle pursuit ensued. After several miles, the vehicle crashed into a yard of 101 Sandy Lane. Osborne was observed exiting the driver's side of the vehicle, crashed into the creek bed. He was referred in custody on evading arrest. He's currently on probation, Your Honor, for unlawful carrying of a weapon, possession of marijuana less than 2 ounces, and theft of a firearm. Those were all consolidated, placed on a year's probation. He's currently in CPS custody at this particular point. He and his from the home around April the 15th. He does have a court hearing that's set for June the 3rd at 1:30. The CPS worker or COCK worker requested a psychological and a psychiatric evaluation. He has a psychological that's scheduled for June the 3rd at 9 o'clock. The psychiatric, according to Dr. Menchaca, stated that it'll be next Wednesday before he can get a psychiatric evaluation for medication management.
All right. Ms. White, Ms. Garcia, what are your thoughts? Or Garza, sorry, Ms. Garza or Ms. White.
Well, he's more than welcome to come to my home. He can care for himself.
All right, Ms. Garza?
Yes, sir.
What are your thoughts?
Well, currently we are trying to find placement for Mr. Osborne. However, due to his criminal history and stuff, we're having issues of trying to find anything for him. We also would like for the psychological to be done because it may be able to help us in order to find a placement for him. He's had several arrests recently. And when he ran after being placed in foster care and was picked up on May the 6th, he was taken to his grandmother's house. And the concern is that grandma didn't even let us know that he was there. We had to have the police go out with us to find him because we had gotten word that he was there. And I mean, that's our concerns right now. So we would like to detained in order for us to be able to find a place that's appropriate for him. And we're also doing a home study on the grandmother. I've requested. There are some other concerns in the home because there's an individual that has criminal history as well. So we were wanting a formal home study completed.
All right, Ms. Daniel, what are your thoughts?
Well, Your Honor, while I do understand the department's concerns, because Mr. Osborne is, I guess, been a runaway while in CPS custody, the only stability he does have is with his grandmother, Miss White, and that's where he goes. And I believe that with the order of the court and ankle monitoring, I believe that placing him with his grandmother, that he would follow the guidelines that Your Honor would request of him. So therefore, I would, ask that pending the home study that he be placed with his maternal grandmother.
All right, Ms. McGonigal, you get the last word.
Thank you, Your Honor. Your Honor, I've spoken to AJ. He does want to go to his grandmother's house. When he was on the runaway from the CPS foster home, he was still in contact with Ms. Washington, his PO. So he wasn't keeping in touch with OK, but he was keeping in touch with Ms. Washington. I also would like the court to know that the offense report, I read it. Not getting to the facts of the case, he's actually been charged with evading on foot. He was not the driver. The officer was mistaken. He's been charged with a felony offense, misdemeanor offense, not a felony offense, if that would help the court. AJ does want to live with his grandmother. I think the monitor will help him stay in the house and be stable. I've spoken to Ms. Garcia. Ms. Garcia, who is Ms. Garcia's supervisor, about their concern. This was mentioned over a week ago that we were looking at grandma. So I'm not sure why OCOK hasn't really been able to do an abbreviated home study pending a formal home study on grandma to satisfy their concerns. I don't think keeping him in detention pending psychological that they're asking for is appropriate for AJ. He can go to a psychological appointment and have that evaluation done if he is released from court from detention. We do have court on the 3rd. It's in the afternoon. I've spoken to Ms. Washington, but I will be speaking to Ms. Farmer. I think that we're going to go ahead with adjudication and pass disposition and just wait for the psychological to come in, since it's really being requested by OCOK, not through probation. I do think the monitor is appropriate because he did run from that last foster home, but he did run to grandma's house, and he is representing that he wants to be at grandma's house. So we'd ask that he be released today or to comply with any testing that has been scheduled on his behalf and be on the monitor.
All right, thank you, counsel. Mr. Osborne, you saw me 2 weeks ago, right?
Okay.
What did I tell you then? What level do you need to be at for me to consider your release?
Level 1.
Level 1 what?
1-0.
Yes, what are you at?
1A.
Correct. Did you meet your half of the bargain?
I did, but no.
No. What's the answer? It's a yes or no answer. Are you level 1-0 right now?
No, sir.
Okay. And you have a history with the department. And so because you're not at level 1-0, I can't have faith that you can follow the rules if I let you go to grandmother's. Okay? That's why I require you to get to level 1-0 to show me that you can follow the rules, but you're not there yet. So based on the information before me today, I'm going to order that you be detained. I'll see you next week.
Okay.
Thank you, Judge.
Thank you. That'll be the order of the court.
Thank you, Your Honor.
Thank you.
AJ! AJ!
Yeah.
So there's Bob. All right, you Mr. Mayfield?
Yes, sir.
All right, Mr. Mayfield, my name is Judge Porter. This is a detention hearing to determine if you should remain in custody or be released to a parent or guardian. You have the right to remain silent and not say anything at all. If there is something you want to say, please do not just yell it out. Instead, I want you to wave your hand like this I'll create a private internet chat room for you and your attorney to talk. Do you see Mr. Hall on the screen?
No, sir.
Okay, keep looking around. He's waving his hand at you?
Yeah, no, I do.
Okay. So if there's something you want to say, wave your hand like he was doing. That'll get my attention. I'll create that private chat room for you and Mr. Hall to talk about what you want to say. That way he can advise you on whether or not you really should say it. Does that make sense?
Yes, sir.
All right. Anything you say at this hearing can be used at a future detention hearing, but not at an adjudication or disposition hearing. So, Mr. Lewis, Mr. Mayfield is here on a manslaughter charge, correct?
Yes, sir.
All right, and he's got ties to Wyoming, correct?
Yes, sir. On that note, the link for today's Zoom meeting was sent to his mother in Wyoming and an aunt who resides locally.
Okay.
I believe they may be somewhere in the meeting. I just can't see them on my screen.
Okay, I'm looking.
The names would be Sarah James and Laura Corona.
I see Laura Corona waving at the camera. And
yes,
at the camera.
Okay, I need y'all to take your phone off or computer off mute. There you go. Okay. Okay. State, let me ask you this. Do we have a setting on this case? Why has it been 155 days without a setting?
Judge, I spoke with Mr. Boneberg earlier today. He indicated that, part of the reason is this case has been set a couple times, but the trial keeps getting kicked out due to COVID. He was speaking with Mr. Hall about setting a trial. It sounds like it's unclear whether it's going to be a jury trial or a bench trial, but we are working on trying to set this as soon as possible for a setting. Mr. Hall may have more information.
Yeah, Mr. Hall.
Yeah, we talked this morning, me and Kevin did. It's going to be a bench trial, and we're looking at June 29th.
Okay. I think both sides understand why the court is starting to get antsy that a kid remains in detention for as long as Mr. Mayfield has.
Yeah, if he was in a facility in Wyoming, Judge, and we had to wait for him to be released back here, is what's taken so long on it.
Okay. Any additional thoughts, Mr. Hall?
His aunt's wanting him to stay, with her. Mom's also in agreement with that. And so is my client. So I'd ask that he be able to go and stay with the aunt so I can have more access to him while we're getting ready for trial. And he's assured me that, he'll stay in the house, whatever he has to do. They've got some younger kids in the home, but the aunt's there 24/7. So she's, there where she can watch over everything.
Judge, we'd object on a safety basis, the charges pending are involving a child victim and are very serious. With the date set in late June, we'll be having an expeditious setting and we can get this thing resolved quickly.
All right.
And Judge, the victim was about the same age as my client, just a couple years younger, I think.
Okay. Mr. Mayfield, we've talked before, and one of the things that I take into account when I make this assessment is how good you've been back in the back, and you've been incredibly well behaved back in the back. Another thing I need to consider is your ties to this community and the availability is for you to be able to leave the court's jurisdiction. Third thing I have to think of is the seriousness of this offense. But in the back of my mind, there's always this thought of how long has this kid been in detention? And I don't like keeping kids in detention waiting trial. That's not fair to them. Mr. Richmond, I am right on the precipice of releasing him because this is almost becoming coercive to him. It is not fair to him to have such outstanding behavior in the back and yet remain in detention. And at some point, that is detrimental to his well-being. We're on the precipice of me ordering him being released. I am not there yet. I think the gravity of the underlying offense is still too serious. So today I am ordering that you remain in detention. But Mr. Richmond, the state is coming dangerously close under Barker versus Wingo to getting this kid released.
I understand the court's concerns. Part of the delay I know is because up until recently, he was insisting on a jury trial. The court wasn't able to set jury trials for a couple months. I believe there were settings on May 4th and June 22nd, but those dates couldn't work. But now that there's a change to the bench trial, we can do it sooner. I stand on the arguments before, but I'll make sure Mr. Boneberg is aware of the court's position.
All right. Thank you. That's going to be the order of the court.
Judge, if I may.
Yes, sir.
The reason he was in Wyoming was because mom had talked to the police and they said she was free to go up there as long as she stayed in contact with them or they had her contact information, which she did. So there's no threat of him going back up there.
Yes, but it's the availability of going somewhere else because he's 16. He's a little bit more sophisticated. He could probably figure out how to get up there if he really wanted to. That's a bunch of different factors, but Mr. Hall, your considerations are well made. All right. Thank you all.
Okay.
Have a good day.
A judge is Randy on or I haven't seen
She is. She is.
Okay, thanks. I'm off of here then.
All right. Have a great weekend.
You too.
Peters, if you want to take yourself off mute. There we go. All right, welcome back, Mr. Eric. My name is Judge Porter. This is a detention hearing to determine if you should remain in custody or be released to a parent or guardian. You have the right to have this hearing recorded. If you want that hearing recorded, your attorney, Ms. Bowers, will let me know. Do you see Ms. Bowers on the screen?
No, I don't see nobody. It say mute. I don't see nobody.
Okay, look for the lady with dark glasses. Do you see her? She's smiling real big.
I see her. Hey.
Okay. Now, you have the right to remain silent and not say anything at all. If there is something you want to say, please do not just yell it out. Instead, I want you to wave your hand like this. That'll get my attention. That'll also get your attorney's attention.
Yes, sir.
I'll create a private internet chat room for y'all to talk about what you want to say, okay? That way she can advise you on whether or not you really should say it. Does that make sense?
Yes, sir.
Anything you say at this hearing cannot be used against you at an adjudication or disposition hearing, but it can be used against you at another detention hearing. All right, Ms. Peters, what brings Mr. Eric to court today?
Your Honor, AJ is the companion, Terry's the companion of Osborne, AJ, in the stolen car that occurred on the 8th. We have a long history with this department, just with what we've been trying to do with him. Back in November, he came in for a UUMD for a stolen car. He was brought in, released because of his doctor's appointments. He left. We had another warrant out for him in December. He came back in late December, and we re-released him again, and then he violated the monitor in February. I haven't seen him since February until he came in on the 8th. We had an initial psych done, and we had some concerns with his IQ. And so we have a fitness to proceed psychological scheduled for this Sunday. It comes back on the 1st, and we have a fitness hearing on the 2nd.
All right. And Ms. Eric, you're here in the courtroom today, correct?
Yes, sir. Yes, sir.
All right. Ms. Bowers, what are your thoughts?
Well, I have spoken with Terry this week and last week. Of course, he wants to get out again. My big concern is that we've been trying to get this fitness to proceed evaluation done for a while. And my concern also is that when the probation officer spoke to him on the phone during part of this time that he was gone, he refused to come in or come home so that he could be brought in. So I have some concerns about that. I know he wants to go home. I understand that. I get that. But we need to have this evaluation done so that we can decide what needs to be done with him.
All right, Mr. Eric, I saw you nodding your head. You understand the importance of those meetings you got coming up?
Yes, sir.
All right. It's real important that we get you to see those doctors, okay?
Yes, sir.
All right. To make that happen, I need you to stay here, okay?
Yes, sir.
All right. Then that'll be the order of the court. Thank y'all.
Thank you,
Thank you, Your Honor.
Thank you.
Thank you, Your Honor.
We are done. Y'all have a great weekend.
Thank
you, Your Honor. You too.
Bye.